Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law. Please subscribe to our channel. Oftentimes we're asked whether or not inheritance is considered marital property in the state of Michigan. Well, the quick answer is it's not considered marital property. It's really the opposite of marital property. That is, it's considered separate property. But there are things that a person can do to an inheritance which transform it from being separate and make it marital. So if you're married and a loved one dies and leaves you, some money in the bank or a piece of property or something like that, the lawyer gives it to you as a title or a deed or an account. It's in your name. It's kept separately. You keep it separate the whole time. It's likely that the court will consider that that was not marital property. That was an inheritance. That's not something that either party really worked to get. So therefore, if there's a later divorce, the court may well not consider that a marital asset. However, there are things you can do to change that. If you take the money, for example, that you inherited and then deposit it in your joint bank account, you know what you've done? You just made a gift to the marriage. It's now become marital property. And now if there's a divorce, it's going to be subject to 50-50 division or some division. Now sometimes the court can look at it as a function of fairness and say, well, the inheritance is yours, I'm going to let you keep it, but because of the overall situation, I'm going to count the increased value of it during the marriage as a marital asset. So let's say you inherit $100,000, and because of interest, and you've kept it separate, but now it's grown to $120,000, and now the parties get divorced. The court has the discretion to say, look, the 100 is yours. It's a marital asset. It is not. It's an inherent asset. Goes to you. So we're not going to count it marital, but the growth, we're going to count that as marital, which means half of that growth might be hers, half might be yours. So in this scenario, if it grew to 120, you'd get the 100. You'd get half the 20, which is 10. She'd get the other 10. So you'd have 110, she'd get 10. And that's how that would work in that scenario. And the court does have the discretion to make that kind of analysis. If you have a question about that, reach out. Of course, we'll be glad to help you out.